Thank you for your propositions, Mr. Driscoll. That's very good of you.
My Lord, I was taking your lordships through Transport for London and Spiros. I'd drawn your attention to paragraph 16 of the speech of Lord Walker, and could I just draw your attention to 19 and 20. This is where Lord Walker deals with point scored, which, as you can see, is a decision of the Judicial Committee of the Privy Council. And then if I just pick it up at letter G on page 1805, just above letter G, Lord MacDermott quoted, that's in point scored, from the judgment of Mr. Justice Eve in a case antedating the 1919 Act in the South Eastern Railway Company, increase in value consequent on the execution of the undertaking, for in connection with which the purchases may to be disregarded. Quotation was arguably out of context, since the South Eastern Railway case involved the acquiring authority trying to reduce the amount of compensation on the ground of betterment. And then Lord Walker says, quite apart from its subsequent history, I find point scored itself a rather surprising decision. And then he refers to section 2.3, which is the same as rule 3 that we were just looking at in the context of the 1919 Act and also the 1961 Act. And he says over the page 1806, it would not, I think, have been stretching its language, that's rule 3, unduly to treat it as covering the expected increase in profits from the quarry. Instead, the Privy Council seems to have taken the view that the extra profits are outside the express statutory provision. That's because courts, for some reason, construed that statutory provision, rule 3, rather narrowly, but were nevertheless within the general value to owner principle illustrated by the 19th century cases, such as the Graveyards case, and embodied in the Trinidad equivalent of Rule 2, by focusing on a hypothetical sale by a willing vendor without any identification of the hypothetical purchaser. The value to owner principle transports the court into a no-scheme world. That's the view that Lord Nichols took in Waters. It's important to keep in mind that despite its late arrival on the scene, the expression the point scored principle is not a reference to a principle separate and distinct from the value to the owner principle. It's no more than the name given to one aspect of the long-established value to the owner principle. And then I was going to take...
Could you just, I'm not quite sure I've picked up what's meant between B and C on 1806. Is that simply a comment on the fact that when you look at Rule 2, it refers to a willing seller but doesn't refer to a willing purchaser?
Perhaps I'm not the best person to answer the question, but whatever one is concerned with, it's going to be a hypothetical. Yes. So it's going to be a hypothetical vendor and it's going to be a hypothetical purchaser, one assumes.
Yes. I mean, you know who the vendor is it? But,
yes, you do, but for the purposes of the valuation exercise, yes, one will assume a hypothetical vendor. It's by a...
well, the whole thing is built on a hypothesis.
It is. But the point that I seek to extract from this speech is that indeed these propositions are... there is a rebuttable presumption adopted by the court in the interpretation of statutes, generally concerned with compensation for the compulsory acquisition of land. It's not concerned with the meaning of a particular word or phrase, but with the general attitude and expectation with which the court approaches a statute dealing with compensation, the compulsory acquisition of land. That's paragraphs 11 and 12. It is that compensation for a compulsory acquisition of land cannot include an increase in value which is entirely due to the scheme underlying the acquisition. Put another way, compensation is to be assessed on the basis of its value to the expropriated owner, not on the basis of its value to the acquiring authority. Apply this reasoning to this case, to the case that we have, we say that where an oil company obtains the right it needs from the court, it acquires it compulsorily.
There's another interesting passage at letter F on page 1806, where you'll see the sentence, Parliament took the formal view treating future development rights as public property. Now, in the standard, the ordinary run-of-the-mill compulsory acquisition, future development is exactly what's being provided for. It's providing the opportunity for something to be done in the future by way of laying whatever it is, a road or building a factory or a harbour or so on and so forth. Perhaps you're coming on to this, but one of the points made against you is that actually what one contemplates in this case underneath Bocardo is an existing apex of oil. And that's something which is actually, as it were, in hand. And admittedly, they don't own the oil, there's no right to take it out, but they have some sort of value attached to the fact that in order to get at it, the person who has the right to obtain the oil has to go through what they argue is their property. And it's not a future thing, they say. It's just simply an aspect of the physical composition of their property, existing physical property.
Yes. But the way that I suggest that this should be approached is this. In 1934, that apex of petroleum was nationalised. No compensation was given for that nationalisation to anyone, for no doubt very good reasons. And the exclusive right to exploit that petroleum was given to the Crown. That is history. Now one is looking forwards to the future. So far as the future development of oil in the public interest was concerned, it was envisaged and provided in the 1934 Act that this would be through a scheme of licensing. Licenses will be granted to companies, possibly individuals, but companies, on terms contained in a license made by Parliament. The terms of the license were to contain model clauses. The model clauses were to be laid down by a statutory instrument. Now, it doesn't really matter whether or not it's the apex of the reservoir or just the fact that there is a reservoir of petroleum underneath the land. In my submission, there's no relevant distinction there. When one asks, well, who would be interested in drilling pipes into that reservoir in the future after 1934, then the answer is that there's only one person, and that's the license holder. And then one asks, well, is the license holder part of the statutory scheme or not? And the answer is, yes, he must be. And then it follows from that you ignore the interest of the only person who has an interest, if I can say that, I've used the same word twice, and that is the license holder. This is the value to owner, not value to acquirer. This is the no scheme, the point gourd principle. The complaint may be that in 1934 the apex of oil was nationalised without compensation. Now, there were good reasons for that. But that's a complaint that the 1934 owner might have. It's hardly a complaint that a person who acquired the land in 1974 or 1988 would have. It's not a loss suffered by that person. But the only answer I can give to your lordship is that the fact that the land lies over the apex of the oil is certainly a fact, but the only person who will pay anything or attaches any value to that fact is the petroleum license holder, and he is part of the scheme established by the 1934 Act. And you ignore that interest.
So put that way, any development by way of exploiting the apex lies in the future, because that can't be done until the pipe is put down and so on. And the landowner himself has he can't do that because he's no right to get access to the oil. So you say this is just another example of future development which falls to be ignored.
Yes,
is that it?
Because it's part of the scheme. You're just quite right. The landowner may well be acting in contravention of Section 1, subsection 1, if he himself drills a pipe into the reservoir, because without the consent of without a license from the Crown, because only the Crown can search and bore for and get the petroleum. The landowner himself can't grant the right to search and bore for and get the petroleum to a third party. All he can do is authorize someone physically to lay the pipes, drill the pipes. And so we say that the test of this case, if this is a compulsory acquisition case, and if Section 8.2, previously Section 9.2, has not displaced the usual presumption, and we say it hasn't, the words aren't good enough, and I hope to make that proposition good when we come to look at waters, then this is a classic scheme case, point gourd case, and the only person who will pay for the right to drill pipes into the reservoir is the license holder. The license holder is part of, he's the creature of the scheme. He's the whole purpose of the 1934 legislation. Our point is as short as that, really. But in our submission, it's decisive in this case, as the Court of Appeal itself decided. The other passage in Transport for London and Spiros that I was going to ask your lordships to look at was simply the summary by Lord Collins of the principles of valuation, paragraphs 88 to 91. I stop at 91 because those are the two principles upon which we rely. I don't think the third is relevant to this particular case. But there in paragraph 89, the underlying principle is that fair compensation should be given, a fair financial equivalent, compensation fairly and fully for his loss. Basis of compensation is the value to the owner and not its value to the public authority. The second House of Lords case that I was going to take your lordships to, and I will take your lordships to, is Waters and Wealth Development Agency, which you'll find in volume 9 at tab 100. Now, of course, the Court of Appeal had Waters and Wealth Development Agency before them. They did not have Transport for London before them for some reason which I don't understand. Mr. Justice Peter Smith didn't have Waters before him, but there it is. Land was acquired in connection, Waters and Wealth Development Agency, land was acquired compulsorily in connection with the construction of a barrage across the mouth of Cardiff Bay. The land in question was acquired specifically as a wetland reserve to rehouse, if I can put it that way, wildlife that would be made homeless by the construction of the barrage. The owners of the land that was to be used as a wetland reserve said that they were in a ransom position. Land had ransom value and key value because without acquiring their land as a reserve, the authority couldn't go ahead and build the barrage. And they also argued that the acquisition of the land as a wetland reserve was, if you like, an add-on. It wasn't part of the scheme, and therefore they weren't caught by Point Gourd. The House of Lords held that it was part of the scheme, and therefore the value attributable to the scheme, otherwise this land would not have appreciable value, the value attributable to the scheme was to be disregarded. In this case, Lord Scott took a different view to the other members of the House of Lords. His view was, let's forget Point Gourd, get on with just construing the statutes. But the other members of the House of Lords said it's far too late to do that. And so I'm not going to ask you to read from the speech of Lord Scott, and I hope to be as selective as possible in the light of the way the discussion has gone yesterday and today, in what I ask you to read from the speech of the other lordships. Lord Nichols at paragraph 15, page 1309. This is a passage that the Court of Appeal found useful. I'll extract from his speech. As he develops his argument, you can see how the words that are to be found in section 8, subsection 2 of the 1966 Act are sort of caught up in his analysis of value. And he says in paragraph 15, the Land Clauses Consolidation Act 1845 used the undefined expression value as the yardstick for compensation. The Act didn't enlarge on what was meant by value. On the face of the statute, nothing could be simpler or fairer. In exchange for his land, the owner should receive its financial equivalent. The financial equivalent, at least ordinarily, is the price obtainable by the owner if he had himself sold the land at the relevant time. In other words, the value of land is the price which the owner could reasonably expect if he'd sold the land in the open market. Implicit in this open market value approach is the notion that, in the customary jargon, the owner would be a willing seller and the purchaser a willing buyer, or they're a willing grantor, a willing grantee. In our case, we're talking rights, not assets or properties. Compensation would be assessed by reference to the price a willing seller might reasonably expect to obtain from a willing buyer. And then there's a definition of what a willing seller is. The seller should not be regarded as disinclined to sell, nor should the buyer be regarded under any urgent necessity to buy. And there's a reference to the Indian case. 17, on an arm's length sale in the open market, a seller would normally expect to realize any enhanced value possessed by the land because its location makes it specially valuable to a particular buyer or class of buyers. This is Bocardo at this stage. There it is. It's got the land over the apex to the oil field, and it has an enhanced value on an arm's length sale in the open market. The land might have particular attraction and therefore value to an adjoining landowner, or the land might be particularly adaptable for a certain purpose. Illustrations in the 19th century include use as a reservoir or use as part of the route for a railway line. Stopping there, of course, most of the statutes which gave rise to compulsory acquisition were statutes concerned with the development of railway lines for privately owned railway companies. Examples today would include development for housing or as a light industrial estate. A willing seller could reasonably expect to benefit from these characteristics of the land if he were to sell it to an adjoining landowner or a water undertaking or a railway company or a developer. The special suitability or adaptability of the land for this or that purpose is part of its market value. All this, therefore, would seem to support, if I again interpret at this point, would seem to support the way in which Bocardo puts its case. Thus, a house worth $750 as a house, but $1,000 as an annex to an adjoining nursing home has a market value of $1,000. IRC in Clay. In principle, subject to one qualification, this approach is equally applicable when assessing value for the purposes of compensation. It's this qualification which has given rise to difficulty. The qualification is that enhancement in the value of the land attributable solely to the particular purpose for which it's being compulsorily acquired and an acquiring authority's pressing need for the land for that purpose are to be disregarded. If statute authorises, and then it goes on to deal with the graveyards case, if that's an example. And then he says at 1310, third line down, this is implicit in the yardstick of value. When granting a power to acquire land compulsorily for a particular purpose, Parliament cannot have intended thereby to increase the value of the subject land. Increase is emphasised there, but what again I would say that in this case, when one looks at the 1934 Act, which I'm going to ask you to look at again, if I may, you will see that the land has been the oil has been nationalised, and then there are provisions for the future exploitation of petroleum, and it is through the provisions dealing with the future exploitation of petroleum that Bocardo seeks to claim what we would say is an increase in the value of the subject land.
Is the idea then that the nationalisation in effect freezes the value of the oil, takes it away, so that any value that was attributable to the presence of the oil in the land has simply disappeared?
Yes.
And there it is. And
I suppose there was just subsection 1.1. And
having done that, is it that the fact that there's an ancillary right that needs to be deployed in order to take it away, you shouldn't be allowed to increase, to put, as it were, back part of the value that's disappeared?
No. The way in which it was put by Lord Justice Sullivan in the Court of Appeal in the course of an exchange was that what unlocks the value is the licence. It's the licence that unlocks the value. Now, if there had just been Section 1, oil has been nationalised, only the Crown has the right to exploit it, let's say. And that was all there was to it. And then Starr came along to Bocardo and said, well, can we drill into your land in order to get to the oil? The answer to that would be, well, no, because the oil doesn't belong to me and I can't give you the right to drill into my land, and you've got no right to do so. It's contrary to Section 1. So, why is Starr in a different position? I'm assuming at the moment it was the licence holder at the relevant time. Why is Starr in a different position? It's in a different position because what it has is the licence granted by the Crown. It holds the licence. The licence unlocks the right to exploit the petroleum. But the licence has been granted pursuant to a statutory regime. It is part of the statutory scheme. The Secretary of State puts it in his submissions in a different way. He suggests that what Bocardo is trying to do is through the back door, by a side wind, I think the back door is the expression he uses, seek to obtain compensation for the nationalisation which took place in 1934. And indeed, in my submission, that is what...
Well, I don't think you... I mean, They're not really doing that, are they? Because they're not actually wanting compensation for the loss of the oil. But what they say is they haven't been denied the right to compensation for loss of the access to the oil.
Yes.
I mean, it's not the oil that they say they're... Because if they wanted compensation for loss of the oil, they'd be entitled to a lot more than 12.5%.
Yes. Well, maybe. So far as I know, your Lordship is no doubt right, but so far as the 12.5% is concerned, I would ask your Lordship to bear in mind, I'll come to this later, that it's on Bocardo's case, it's 12.5% to the to Bocardo, and then 5 to 12.5% to the actual owner of the petroleum. There are two royalties that the oil company have to pay here. I know this doesn't arise out of the Lordship's observation, but just going through my own mind. But it may be that is right there. But so far as the claim that Bocardo is making, what it is seeking to do is to obtain a value from the scheme without which it would not have that value.
Well, certainly that. Of course that.
And then paragraph 19, this approach is encapsulated in the time-hallowed pithy of imprecise phrase. Now, I've read this to you before, but there it is, a reference to Stebbing in the graveyard case. And then in paragraph 21, drawing a distinction between value to the owner and value to the purchaser makes it necessary to distinguish the one from the other. It's necessary to separate from the market value of land any enhancement in value attributable solely to the presence of the acquiring authority in the market as a purchaser of the land in exercise of its statutory powers. It's important to recognise that for this purpose, it's not the existence of a power of compulsory acquisition which increases the value of land. What is relevant, because this may affect the value of the land, is the use the acquiring authority proposes to make of the land it is acquiring. Accordingly, in identifying any enhanced value which must be disregarded, it's always necessary to look beyond the mere existence of the power. It's necessary to identify the use. Hence the introduction of the concept of the scheme or equivalent expressions such as project or undertaking. Lord Nichols then dealt over page with the Acquisition of Land Assessment of Compensation Act 1919. In paragraph 6,
Paragraph what?
Paragraph 26, I'm so sorry, 26. The value, he says this, the value to the owner judicial interpretation of value in the Land Clauses Consolidation Act 1845 might have been expected to limit the amount of awards, but by 1918 it had become notorious that compensation paid for the acquisition of property for public purposes was in many cases excessive. That was the view of the Scott Committee, Lord Justice Scott, in its second report on the law and practice. The committee identified several causes, including the absence of any definition of value in the 1845 Act. In its report of the committee, in its report, the committee made recommendations aimed at reducing the amounts of the award. These included recommendations that the customary allowance added to the price of the land should be abolished, and that the standard of value to be paid to the owner should explicitly be stated as the market value of the land as between a willing seller and a willing buyer. Of course, if Bocardo are right, that if they just left it there, it might not have been enough. The customary allowance was the 10% or more, and what happened was that hand in hand with limiting the value to the value to the owner, not to the acquirer, the courts at the same time added 10% or more to the value, to compensate for that, if you like, basis of valuation. So far as I'm aware, Section 3, subsection 2 of the Petroleum Production Act, 1934, is the only example of a statutory recognition of what was in fact a judicial add-on. But it was something that the courts, or the assessors and valuers added at the same time as they were limiting the valuation to value to owner. I think I stop at that point, but I would refer your lordships 26, 27 and 28, and you'll then see that Lord Nichols then considered the Indian case. I'm not going to take your lordships to that passage in the judgment at all, except perhaps I ought to draw your attention to 36. The Indian case, is, I would agree, a difficult case, and the cases that have subsequently tried to apply it have not always been consistent. Lord Brown, in this case, thought it was best treated as a rather special case in which there were in fact two schemes. One was the statutory scheme, which had to be disregarded, and the other was a non-statutory scheme, if I can call it that, which could be taken into account. But so far as paragraph 36 is concerned, perhaps I can just read it and then make the point I wish to make. He says that, second sentence, in practice, this aspect of the Indian case, which he's set out at paragraph 33, seems to be left largely on one side by the higher courts of this country. Potentiality is part of the market value of land and must be taken into account when assessing compensation. Potentiality should be valued even if the only likely purchaser is the acquiring authority itself. That was decided in the Indian case. But importantly, market value does not include enhanced value attributable solely to the particular use proposed to be made of the land under a scheme of which compulsory acquisition of the subject land is an integral part. This element of value is not part of market value because it is not an element the owner could have realised in the open market. That is the traditional view, which has long been acted upon in this country. It is much too late now for judicial interpretation to set the law on an altogether different course, even if that were otherwise appropriate. Potentiality is to be assessed and valued as matters stood before the particular scheme of which the subject land's acquisition is part came into being. So far as the date of valuation is concerned, in my submission, it quite clearly is the date upon which the licence holder seeks to acquire the land in order to exploit its licence. It's at that date that one has to value the interest that it is acquiring. And one asks oneself, what value do the rights which it seeks at that valuation date, when it seeks to acquire the land, what value do those rights have in the market? Bocardo's rights to grant the right to drill pipes underneath its land has no value at that time. Going on in the speech of Lord Nichols, he deals with ransom value. And you've been taken to this passage, and I won't therefore read it to you again. I would ask you now to consider it in the light of the principles of valuation which have been well established by the courts from, as I say, the 19th century and are now being confirmed by the House of Lords as recently as 2004 and last year. This deals with ransom value.
This is paragraph 64.
64, yes. 64, 65, 66, yes. I believe you've already been taken to those passages. My answer to them is that there was no ransom value, there was no premium value, there was no value in the land at the time that the license holder exploited the license, which was part of the statutory scheme. Of course, in this case, the license holder, I should make it clear, of course, in this case, the license holder did not use the statutory machinery, but we're looking at the statute in order to determine the context in which the hypothetical negotiation for the purposes of common law damages would have gone. I think it's accepted by both sides that the correct interpretation of the statute would have influenced and determined how that reasonable negotiation would have gone.
I'm quite sure I grasp what you're saying about this. Are you saying it has no value, or it has a value which has to be disregarded?
What I'm saying is this. The land has a ransom or key value, but the only person who can be ransomed is the license holder. He is part of the scheme, and therefore that ransom value must be ignored. Now, there will be cases. Batchelor and Kent County Council was one, and another case that you were taken to. Chapman Lowry Puttick Limited, I think, is another, volume 4, tab 39, where the land had a ransom value because other developers could be interested in acquiring the land, and they too were ransomed by not being able to acquire the land. And so where land has a ransom value in the market generally, then simply because it's being acquired compulsorily does not deprive it of that value. Put another way, you've got to find someone other than the acquiring authority who's going to be interested in paying the ransom. Otherwise, it doesn't have a ransom value in the market. But all that these cases say is that if there is a ransom value or a key value, which is applicable in the market, then the fact that it's being compulsorily acquired for the purposes of a scheme does not mean that you disregard it, unless it's only the scheme which is being ransomed. I think I've probably said the same thing more than once, but that I think is the point about Batchelor.
So this land would have had a ransom value before 1934, but it was really removed by the scheme, was it, which came into existence in whenever it was 1934.
No,
Before the nationalisation of the oil,
yes,
the oil was there, and this value would have had a market value. That this right would have had a value in the market, which would include its key value.
yes.
But your analysis leads to the conclusion that that's removed by the statute.
Yes. Right? Removed by the statute.
Because of this principle.
No. That value was removed by the statute because the oil was nationalised, and the only right to exploit the oil was conferred on the Crown. The scheme, and this may well be one of the questions for your lordships, the scheme, in my submission, is the scheme going forward after it had been nationalised. The scheme, after the petroleum had been nationalised, the scheme is the scheme set up under the 1934 Act, by which the Crown grants licences to oil companies on terms approved by Parliament for the development of different territories within Great Britain for exploiting oil. So the scheme is the licensing scheme, but Parliament has already expropriated, if you like, has already expropriated without compensation if one wants to put it that way, the oil itself and the exclusive right to exploit it. And there were many good reasons why Parliament did so. Lord Brown.
The actual property in the oil and the right to get it were expropriated without compensation.
Yes.
They were nationalised.
Yes.
What is left is the subsidiary ancillary right to access it through land. That hasn't been expropriated, it's barely been the subject of a further scheme which enables it to be gained compulsorily.
Yes.
But on compensation.
Yes.
And the question then is, what does the 8.2 compensation allow? Does it or doesn't it allow anything at all in respect of the value to the purchaser?
Yes.
And I mean, that's the issue.
It is that is, I'm afraid, it. And what I rely upon is the approach, now very well established, and well established in 1934, of the approach of the courts to the determination of open market value. It is not open market value in a free, unrestricted world. Of course, a Parliament might express itself in a different way, but what I'm suggesting to you is that the words used in section 9.2, then section 8.2, aren't good enough. And you can see if you trace through the concept of value, open market value, and what does open market value mean? It means what a willing buyer and seller would agree. You can see that we are, by that process of reasoning, Lord Nichols is really reasoning in Waters, and using exactly the same words as one can find in section 8.2, as it now is. And also you can find the same words in Rule 2 of the Land Compensation Act and the Acquisition of Land Act 1918. Lord Brown deals with the point gourd principle, paragraphs 131 to 131.
I mean, I think in 142, I basically say much the same as Lord Walker said thereafter in Spiros at paragraph 20.
Yes.
Point gourd was
Perhaps I can deal with it.
rather surprising because actually it was all apparently able to be dealt with under Rule 3.
Yes, but then, my Lord is obviously right, but at the end of the day, it was dealt with under point gourd rather than Rule 3.
Yeah.
So you don't need Rule 3 in order to arrive at the result. And therefore, you're just left with Rule 2, which you've looked at, which is expressed in remarkably similar words to the Section 8.2. But one can see it, just tracking back a bit, paragraph 121.
Where are we looking?
121 in your Lordship's speech.
121.
Yeah.
121. I'm sorry, I'm going back.
Yeah.
So
You
this
see
is the
there
key.
that the claim in short,
Yes.
they claim in short what is sometimes called the land's ransom or key value, the value of the land needed to unlock the development potential of a linked site, called in the court below the land's barrage inhibition value. So really that's the same sort of point as being put to you now in the context of a different act, certainly. 125, a reference to point gourd, and then in going back to where I was, paragraphs 131, then on really to 139, the Lordship explains why it's not just Rule 3, it's going to be a point gourd. And so 132, the Lordship says, put aside the long series of posts, 1961 Act Court of Appeal authorities, all decided by reference to the Point Gold rule. And then 131, put aside the many references to the Point Gold rule in the opinions given by your Lordship's House and the Privy Council. And then 134, put aside further the Law Commission's report, number 286, the entire consultation process underlying it, all of which proceeded on the footing that the existing law is not simply that to be found in the legislation, but also unsatisfactory, though this too may be in the case law surrounding the Point Gold rule. And then 135, what to my mind makes it particularly inappropriate at this late stage simply to ignore all the cases over the last 45 years, save those few which have to construe and apply the governing legislation, is what I take to be Parliament's own recognition, which itself dates back to 1980, that compensation may not fall to be assessed exclusively by reference to the statutory code, but may also have to be determined as to disregards by rule of law. And then there's reference to the 1961 Act. Paragraph 10 of this schedule shall have effect in relation to any increase or diminution in value to be left out of account by virtue of any rule of law relating to the assessment of compensation in respect of compulsory acquisition, as it has effect in relation to any increase or diminution in value. And then Lord Lordship says in paragraph 137, nor, moreover, tempting, though in one sense it might be, to return to the unadorned language of the statute, should your Lordships regard with any particular enthusiasm the prospect of subjecting the next generation of litigants to the very real problems which that language has itself created. And that, of course, is a reference to the 61 Act. And they are normal, tempting, in one sense it might be. And then, in your opinion, therefore, it's better that your Lordship should now seek to apply and, where necessary, modify the case law as it has evolved over recent years and discarded in its entirety. In this way, English law will remain in harmony with that of other jurisdictions substantially modelled on it. And then there's a reference to the section 56 of the New South Wales legislation and the definition of market value, which expressly disregards any increase or decrease in value caused by the carrying out of or proposal to carry out the public purpose.
This case was, on its facts, a very striking one, where it really was all ransom value down to the scheme, wasn't it? I mean, we see from the first paragraph of Lord Brown's speech that it was low-level, low-lying farmland. The only special quality it had was it was low-lying, and it was turned into saline pools, and I don't know whether that should be reed beds rather than seed beds, but anyway, it was turned into a place where migratory birds could live, and one would have thought it probably was actually worth less than its agricultural value, with paragraph 10 of Lord Nichols, which was 4,500, and the claimants are asking 28,000 an acre. I mean, it's a pretty striking example, isn't it?
Yes, but so too is this case. Before your Lordships, in this case, the strata have no value at all, except that because of the licence holder's need to access the apex of the oil, the landowner says that it's worth hundreds of thousands of pounds. It's entirely down to the scheme. Without the scheme, the landowner's land rights would be valueless. There is a reference in paragraph 139 that, and I essentially rely upon paragraphs 131 to 139, and then some other paragraphs I'll just, as quickly as I can, draw your attention to. There's again another reference to the 10% addition. Lord Justice Scott, chairman of the committee, was later saying Horn and Sunderland, which is in the bundle of authorities, that Rule 1 had abolished the 10% addition for compulsory purchase. Rule 2 had reversed the old sympathetic hypothesis of the unwilling seller and the willing buyer, which underlay judicial interpretation of the Act of 1845. then going on, I rely upon the passages which are contained in paragraphs 146, 147, 150, 156 to 162, and perhaps I'll just briefly explain some of those paragraphs. In paragraphs 147, my Lord sets out the recommendations to be found in Rule 13 of the Law Commission's proposed new conduct on compensation in compulsory purchase cases. And so this is paragraph 147. And essentially, as I read Your Lordship is saying that this proposed new code sets out, in effect, where we are with Point Gould. Except that the scheme is now called the statutory project. And Rule 3, just opposite letter C, in cases of dispute, the area of the statutory project should be determined by the tribunal as a question of fact. The statutory project shall be taken to be the implementation of the authorised purpose within the area of the compulsory purchase order, save to the extent it's shown that it's part of a larger project, save by agreement or special circumstances, the tribunal shall not permit the authority to advance evidence of a larger project, and then disregarding the project. This is in valuing the subject land at the valuation date, it shall be assumed that the statutory project has been cancelled on that date. Now, that is perhaps an interesting way of looking at it. Just assume at the date on which one comes to value the right which the license holder, petroleum license holder is seeking. Suppose that on that date the license has been cancelled. What value, what conceivable value would the rights have to the former license holder? The following matters should be disregarded: the effects of any action previously taken, including acquisition of land and any development or works by a public authority, wholly or mainly for the purpose of the statutory project, the prospect of the same or any other project to meet the same or substantially the same need being carried out in the exercise of statutory function, or the exercise of compulsory powers. And then towards the end of the
sorry, I'm just trying to think. When a local authority wants to, take our old friend Tesco and Sainsbury's, they want to assemble land for a particular project. They very generally they try and do the thing consensually first. They go around to various owners and say, undoubtedly they would then be paying the value, would they not, with this project in mind? There isn't yet a compulsory purchase order, so you don't disregard the fact that if they decline to buy, if the local authority decline to buy the land, they will then get a compulsory purchase order. Then they'll be able to buy it for all the world as if there wasn't going to be a development on it. How does it work there?
Well,
I'm not trying to articulate it very clearly.
I'm not all that familiar with the Tesco Sainsbury situation in Wolverhampton. But the answer I suggest is that in that sort of case, the land that they're seeking to acquire does have a market value. Waitrose, for example, might be interested in doing the same sort of thing. And so there is a market. There's a market for the land, other than the one person who is interested in it because of the scheme.
Yes, in that very case, both Sainsbury's and Tesco's had been buying up parts of the relevant development area.
Yeah, and if Waitrose bought the interest of Tesco, they'd be caught in the same jam as Tesco would. They wouldn't be able to do anything actually without the agreement of Sainsbury's, and it's So,
No, well, your lordships have a much greater familiarity with the particular circumstances of that case than I'm afraid I do. But my answer is that there is a market there. The market is other than the if you like the single acquiring authority who's seeking to carry out the scheme.
Yes.
And it's rather like the coal. In Markham Colliery, as we'll see in a short moment, in Markham Colliery, the coal company had to pay the market value for the coal. It wasn't able to say, well, I don't have to pay anything for the coal because you can you've got to disregard the purpose for which I'm buying it, because there was a market.
Yes.
But my simple point here is, my short point, is that there is no market for these pipes, as we call them, in the location in which they are, except for the license holder. That's part of the scheme. It is a classic, in my submission, scheme case. Then my Lord Brown deals with Point Gord and Stokes in Cambridge, and in effect distinguishes Stokes in Cambridge, which is of course the well-known case on ransom value. Ransom value is normally start off at 1/3 of the net profit. It's a good start, a starting place, but there is no Stokes in Cambridge position here because it's all part of the value is derived from the scheme. And then finally, and this is why I'm lastly taking you to this part of the speech, 161, your lordship deals with the Indian case, and I don't propose taking your lordships to the Indian case, but I would ask your lordships to accept that the way in which Lord Brown deals with it in 161 and 162, and say it's really to be distinguished on the basis it's a two-scheme. It's a two-scheme case. And it's 162.
Certainly. Justice Beale Handley thought that also in New South Wales.
Yes. Well, if it's good enough for your lordship, then it's certainly obviously good enough for my purposes today. Can I now take your lordship to two other cases, much more quickly than I've taken your lordship through those two cases. The first one is South Eastern Railway, which is your lordship will find in volume 8 at tab 90, and I simply take you to this case and the next case in order to illustrate to your lordships that this is not some principle of construction which has emerged since the decision in Point Gord, in other words, over the last 50 or so years. And this was if your lordships have it, this is a compulsory purchase case. In fact, the acquiring authority was not South Eastern Railway, but London County Council. It contains a statement of principle which has been regarded for some time now as a valuable statement of principle, a short statement of principle contained on page 258. The case went on appeal, but the appeal was dismissed. And this is the passage that is frequently referred to because it contains a short statement of principle. Again, it's concerned with the meaning of value, and it's the value to be ascertained, it's at the foot of the page, is the value to the vendor, not its value to the purchaser. I don't think we're really concerned with two, but in fixing the value to the vendor, all restrictions imposed on the user enjoyment of the land in his hands are taken into account. I suppose one could say there that by statute he can't actually himself get the petroleum or authorise it. And then 3, market price is not a conclusive test of real value. Increase in value consequent on the execution of the undertaking, 4, in connection with which the purchase is made, must be disregarded. That's Point Gord. The value to be ascertained is the price to be paid for the land with all its potentialities and with all the use made of it by the vendor. And 6, the true contractual relationship of the parties is not to be obscured by endeavouring to construe it as another contractual relation altogether. 4 and 5.
What was Lord Justice Scott worried about if all that had already been established?
Lord Justice Scott.
I thought he was worried that they were compensating too generously. How do you...
Well, he was because what had crept in, as I understand it, was, for example, the 10% uplift that we have.
Well,
in
the
this
10%
case.
uplift's another matter, yes. We've got that anyway.
And there was some suggestion that that in order to compensate for the fact that the
unwilling buyer,
yes.
unwilling seller, and
Yeah, that's right.
But this is the case that I said, rightly or wrongly, had been quoted out of context in Point Gord, because it wasn't the real point of the case that only part of the property was being acquired, and the acquiring authority was saying, look, what I'm acquiring may be worth so much, but what you're retaining is worth more, because now you're going to have a frontage onto the Strand in London. And I thought the real point of the case was put by Lord Cousins-Hardy at page 262 in the middle. I think it's quite clear there's no provision in this Act for taking betterment into consideration. Yes. And you really, that single sentence is more relevant to what they're actually deciding than Mr. Justice Eve's 6 points.
One reason I take your lordships to this is to illustrate that by the time of the legislation with which we're concerned, it was very well established that so far as compensation payable to a landowner was concerned, it was the value to the owner and not to the acquirer. And for the same purpose, can I just take your lordships quickly to Naylor Benzin? This is a 1950 case. You'll find it in volume 6, at tab 73.
Sorry, I didn't get the tab number. 6?
73.
73, thank you.
It's quite clear that all these principles do apply to compulsory purchase situations. The real issue in this case is whether this case is analogous to them, isn't it? Once it is,
yes,
then it follows.
Yes. Well, your lordship uses the word analogous, but in my submission, it's certainly compulsory acquisition.
I think you were really saying it's pari passu, same.
Yes,
yes, I'm not saying. Mr. Gaunt suggested I was simply saying it was analogous. That's not really my case at all. And that the Secretary of State was saying that in fact it was all part, I think, of a common ancestry or maybe or heritage. But I'm saying it's the same. I'm not saying it's analogous. I'm saying it's compulsory purchase, compulsory acquisition legislation. The presumption is, as a matter of construction, and this one would have thought would have been the intention of the legislature as well, bearing in mind all these cases, that it's value to owner, you disregard the scheme. And the words used in 8.2, formerly 9.2, are just not good enough to replace or rebut the presumption, nor indeed is the fact that in this case, one has a provision which says you can only acquire the right compulsorily if it's not reasonably practicable for you to obtain it by agreement, voluntarily. I don't think I've quite got the words right, but your lordships know what I mean. It's a reference to section 3, subsection 2, as it now is. I can't see in my submission, no matter what I can see, in my submission, that requirement by itself, and indeed the words in section 8.2, if taken with it, can't rebut the presumption, or the rule of law or rule of construction, that compensation is never paid on the basis of the value attributable to the underlying scheme.
That
is, I think, the question in this case.
Yeah, sorry, I'm sorry to interrupt you, but I mean, what sort of masks the point a bit is that Section 8.2 is dealing with two different things at the same time, isn't it? And you
Yes.
pointed out already, consideration, all right, for minerals taken away, but it's also dealing under the same wording with the compensation principle for rights and so on. And I think your point is the formula that's used is capable of following both principles. That if it's consideration, yes, of course, you pay for what is being acquired by you because it has a value. It's an asset. It's something that you can, the coal or the shale or whatever it else could have been sold in the market. But if you're talking about compensation for a right which is really being acquired for the purposes of the scheme you're talking about, then you read the same wording, subject to the rules you've drawn our attention to.
Yes. And if I could just...
I mean, it is, it's not self-evident that you're right, is it? Because, you don't have any reference to any of these other, rule, whatever it was, of the 1919 legislation, Section 5 of the 1961 legislation. You do still have your 10% uplift. It's not absolutely categorically clear that this is all within the same approach, is it?
No reference to value. It's in the context of the 1919 statute, which had already been passed when the 1923 statute came in, and one wonders whether Parliament really did intend. But you say, well, the principle is wider than that, see point Gord, and valuing a right, you are in a sense essentially valuing the right. The notional bargain is about the right, and there's no real difference between valuing the right and valuing the land.
No, we make these points, I think. First of all, the language that you find in Section 8, subsection 2, is indistinguishable from the language used by Lord Nichols in Waters to describe open market value. He deals with the fair price, fair and reasonable price that will be agreed between a willing seller and a willing buyer. Secondly, we rely upon my Lord Walker's statement, I think it's in paragraph 12 now in TfL, Transport for London, that this represents not an approach to the construction of one word, value, in section 63 of the 1845 Act, but an approach adopted by the courts wherever compensation is to be assessed in a compulsory purchase case. Of course, it's a presumption, if you like, of construction. It's not certainly open to Parliament to make it clear that compensation will take into account the value of the scheme, the value attributable to the scheme. Thirdly, well, this is an invitation, but from Peter's invitation at the moment, we do refer, both in our printed case and in the authorities, to the debate in Parliament. I know there's a reluctance of any court to look at these sort of things, in which they, the government, because this was a bill introduced in the House of Lords, but the government, both in the House of Lords and the House of Commons, introduced the legislation and the reasons for it and what it was intended to achieve. And whether or not this is...
Sorry, which legislation are we talking about now?
This is the 34 Act. The 34 Act.
34 Act?
Yes.
Is this the Marquess of Londonderry, or is that passage that we saw yesterday?
No, I think that was a different passage that's being... There are, in fact, you will see that in the bundle of authorities, there are 3 references to Hansard in volume. I'm not going to ask your Lordship to look at them at the moment, but in volume, and we refer to them in our printed case, in volume 13, tabs 154, 155, and 156. And what my submission is clear from the passages, particularly in the House of Lords, from the speeches of the members of the, I think coalition government might call it now, the coalition government which introduced the bill in the House of Lords was twofold. One problem in the past had been that there were too many people asking for royalty payments. My submission, which is essentially what Bocardo is asking for, and that was stifling any exploitation or development of oil. And the second point made was that the object of Section 3 was to provide for compensation for, in fact, the loss suffered by the landowner from the presence of oil wells on the
Section
land.
3, was there? Which section? I'm sorry.
Section 3 of the 1934 Act. Let me, in a moment, I'll take a look more to it. The fourth point that I would make is this, that the 1966 Act was a consolidation. In 1950, a judge in the Chancery Division had made it clear that this was a compulsory purchase case, and that the principles of valuation applicable to compulsory purchase were indeed to be applied. And that is Naylor Benson, which is the case I was just about to take you to.
That's in volume 6, you said, I think.
Yes, volume 6, tab 73.
Yeah.
Now, this was, in fact, a right to work minerals. And one can see from the headnote that the question was what was fair and reasonable between a willing grantor and a willing grantee in pursuance of Section 9, subsection 2 of the Act of 1923. It was, in fact, a right to work the minerals rather than access to work them efficiently and properly. And the relevant passage is to be found on page 7 of 9. And it's rather unfortunate it's been copied this way, but never mind. It's just above, it's the bottom 1/3 of the page on page 7 of 9. And you can see what the issue was. As I've said, substantially nothing turns on the provisions of the lease. Forget that for a moment, please. Other than the clauses concerned with the scales of royalty and restoration payments, in order to fix those scales, I have to turn again to the Section 9. My first task is to construe the phrase. Two views have been put forward. On behalf of the respondent, Dunkley, it said that the subsection presupposes complete freedom of negotiation between the parties, in which event it's proper to take into account the favourable circumstances to which I've already referred, in which the applicants are placed in regard to mining operations on this land, and thus justify the scale of royalty payments in the draft lease. On the other hand, it's submitted by the applicants for the consideration of the court in assessing compensation on Section 9. The court should apply the principles thus enunciated by Mr. Justice Eve. And he sets them out. He then deals with Lucas and Chesterfield Gas, and a comment or an observation that could be made is that here he's focused on Lucas and Chesterfield Gas rather than the comment made on the passage in the judgment from Lord Justice Fletcher Moulton in the Indian case, and the fact that what Lord Justice Fletcher Moulton says is not the same as Lord Justice Vaughan Williams said in the same case, but I think really that's a matter of detail, I would suggest, rather than substance. But he then refers just down the page, halfway down the page, to Corrie and McDermott, 1914 appeal cases. Lord Dunedin said, their lordships can accede to this view. I think I've read this passage to you before. It's their opinion, puts upon the word value and amplification of the bare word, treating it as if it was unrestricted value, which it will not bear. And further, the law of compensation being, as they've stated it, namely the value to the owner as he holds, which law has been so often laid down that it must be held to have been known to the contracting parties. It was their lordships think incumbent on the party who wanted the valuation to proceed upon another footing, take care that the words used clearly so expressed it. And then the first two cases arose under the Land Clauses Consolidation Act, Section 63, and then he deals with that, sets it out, and perhaps one can just pick it up. At the foot of the page 8 of 9, Lord Justice Moulton, as to special, which gave statutory force, I should say, to the views of Lord Justice Fletcher Moulton as to special adaptability, but which in my view doesn't apply to this case. And I come back to section 9. It's true that the words in this section are on the basis of what would be fair and reasonable between a willing grantor and a willing grantee, which are to be compared with the words, the value of the land to be purchased in section 63. It's to be observed that the words in section 63 of the latter act in estimating the purchase money or compensation compare with the words the compensation or consideration in section 9. Mr. Justice Eve pointed out the adoption in compensation cases of any other principles than those enunciated by him would lead to startling results, the most obvious one being that it would upset all uniformity of value. Further, as Lord Justice Fletcher Moulton pointed out in Lucas, it would offend against the principle that a man cannot give more than he has. Well, certainly, my suspicion, true in this case.
Well, what's the problem about uniformity of value?
That I assume is that the uniform basis for valuation of compensation in compulsory purchase cases is value to owner.
So it's just saying the principle ought to be applied universally. That's really what he's saying, is it?
Yes, that I think is what he's saying. That's
Of course, what's so odd about this is the dichotomy between value to owner and value not including value to owner is curious, really, as my Lord Brown points out not very long ago. I mean, the key value is part of the value to the owner of his land. That's a very curious feature of the whole thing. So when one says at the end of the day, and therefore designed to give to a man the fair value to him of what is being taken from him, in the ordinary parlance, that would surely include the key value and absent some special rule.
Yes.
So that, for example, if we weren't trying to assess damages in the statutory context, there'd be no difficulty of the common law awarding damages, including the value, or more or less entirely containing the value evaluation based upon the key value.
That is right, but we have now very well established, over 100 years, a principle that for the purposes of assessing compensation or even consideration, come back to that in a moment if I may, in a compulsory acquisition context you ignore the value attributable, which is only attributable to the statutory scheme. But Lord Nichols in Waters accepted, going through the process of reasoning that he did, that at one point, I've forgotten what paragraph it was, at one point you do reach the stage where the value is the open market value, willing seller, willing buyer.
Leaving out one key factor.
Yes. The key factor is the...
one critical factor.
Yes. Yes. But the key factor, what
he says is at arm's length sale, you have regard to it, but then there's the point good or whatever disregard. Is that what you're saying?
Yes.
Yeah. Right.
But you also have to bear in mind that in this case that one, if it is a baby, one doesn't want to throw the baby out with the bathwater, if Point Court can be described as a baby. This may, at the end of the day, be an attack on Point Gould, which the House of Lords has now considered twice recently, and it may therefore lead to some uncertainty in the assessment of compensation. It may lead to questions as to what words are necessary in order to rebut the presumption. The point I would also make in relation to Lady Benson is that this was a decision of 1950. Parliament may well have had this in mind when it passed, by way of consolidation, without amendment, the Mines, Working Facilities and Sport Act of 1966. This is all part of the background, and this is specifically concerned with Section 9.2. In relation to assessment of compensation. Can I now take
Can we just, sorry to hold you back, but I'm just trying to work out what the case is all about. It was royalty payments there, wasn't it?
Yes.
And what was being taken away was actually the clay. And so applying the test that's being discussed here is a royalty payment that would give to the owner of the clay, the landowner, the fair value of what belonged to him.
Yes.
But what was the dispute about? It was all about the quantum of the royalty payments, was it? And I'm
yes,
not quite sure why this all came into argument.
The dispute was about whether or not the price to be paid was the price, the value of the mineral to the owner, the mineral in the ground,
Yes.
or the value to the acquiring authority once it had been able to realise
Oh, I see.
extract the mineral.
So in the ground, you'd have to take account of the cost of getting it out of the ground, is that it? And whereas if it was a value to the acquirer, he'd be able to take it away and sell it in the open market, he'd get a different price for it. Is that?
Yes, to the owner, the mineral might have a value of only £10 because that's all that the owner could get for it on a sale. But to the acquiring authority, it might have a value. Acquiring company, it might have a value of £15 because it can actually do something with the mineral.
Yes.
Which is why it wants to acquire it. So the question was whether or not it should pay the compensation consideration should reflect the value to the owner, the lower value, or the higher value to the acquiring company.
So it's a consideration case rather than a compensation case, but the principle applies to consideration as well as to compensation.
Yes. Yes.
If this
you
is
won't
right.
find in this decision a distinction between consideration and compensation. You will find references to the word compensation. In my submission, it's brought out more clearly once one comes to consider the wording in the Petroleum Production Act of 1934.
Yes.
In this case, that's
Yes.
not a point that emerges from the decision. It wasn't a point that was taken. Can I ask you, first of all, to turn to some of the relevant legislation? First of all, in Volume 1, tab 7, I'm taking you to this for two purposes, but one of which has already been achieved. You are now more than familiar with Section 63, and so the other purpose is to draw your attention to the fact that the Land Clauses Consolidation Act 1845 was intended to provide a common code in respect of acquisitions of land compulsorily under various private acts and so on. And so Section 1 applies, this act shall apply to every undertaking authorised by any act which shall hereafter be passed and which shall authorise the purchase or taking of lands for such undertaking. And then 2, I just draw your attention to the word, the last 3 lines. The promoters of the undertaking shall mean the parties, whether company undertakers, commissioners, trustees, corporations or private persons, by the special act empowered to execute such works or undertaking. It's a very small point, but a point was taken that there is possibly a distinction between a public authority and private persons, but there it is. This is an act which applies in the case of special acts which empower private persons to acquire land.
Does the definition of word lands looking at, it's in Section 3, would that extend to the kind of ancillary rights that we're considering here? It obviously doesn't have to because we have a statutory provision that deals with them, but what it's really contemplating is is lands, hereditaments, that kind of thing, rather than rights over land?
Absolutely, yes. That's my
So the
understanding.
way leave wouldn't be incorporated in the expression, would it?
No, my understanding is that the legislation with which it was concerned was concerned with the acquisition of land, yes. Land rather than rights over land. The Acquisition of Land Assessment Act is in tab 1. Section 1, subsection 1 is whereby or under any statute, whether passed before or after the passing of this Act, land is authorised to be acquired compulsorily by any government department or any local or public authority, any question of disputed compensation. I just draw your attention there to the fact that the 1919 Act was applicable only in the case of acquisitions, compulsory acquisitions by any government department or any local or public authority. To say that the 10% rule had been abolished by the 1919 Act, which I think Mr. Gaunt said, is really taking it too far, because the 1919 Act only applied in the case of compulsory acquisitions by a government department or any local or public or authority. And then if I can take you to the...
So did it go on then in relation to other cases where it went on?
My Lord, that is my understanding of it until I have a date of 1949 in my mind. I'm not entirely sure why, but yes, I think it would have done.
So if the Great Western Railway, for instance, wanted to build a new branch line in 1925, it would have had to promote a special act of Parliament and incorporate the Land Clauses Consolidation Act, would it? And they would have got their 10%. Well, that perhaps gives a clue to why that it wasn't so odd for the 10% to appear in a statute passed in 1923.
1934.
Sorry, 1934.
If I can take you to the 1923 Act, which is in tab 10.
Sorry, I didn't catch that, unfortunately.
If I can ask you to turn to tab 10 in volume 1. This is the Mines Working Facilities and Support Act 1923.
Oh, yes.
It is relevant to look at this Act because this was the Act in the context of which the 1934 Act was passed. But at the relevant date, so far as the hypothetical negotiation is concerned, of course it had been replaced by the 1966 Act. And to some extent, I was proposing now to cover some ground which we've covered already. But I would draw attention that, as my Lord Hope has already pointed out, there were two types of rights available under this Act. One was the right to work minerals, where there was a danger of the minerals being left permanently unworked. And so it's considered to be in the national interest, the public interest, that minerals should not be left permanently unworked. Initially in two particular situations. And so this is the application. Section 1, subsection 1, paragraph A, is the provision under which the coal company applied for rights in Remarkham. It wanted to work minerals which it did not own. The ancillary right was then to be found in section 3. And that was where any facility, right or privilege is required in order that minerals may be properly and conveniently worked by the person entitled to work the same, and the proper and efficient working of the minerals is unduly hampered by the inability or failure of that person to obtain such right. Such ancillary right may be conferred in the manner and subject to provisions hereinafter appearing on the person having the right to work the minerals. And so, section 3, an ancillary right, was available where there was a person who already had the right to work the minerals. And so an application, in some cases, can be made on section 1 and subsection 3. That's the ancillary right that we're concerned with. Section 4(1) is now Section 3(2) of the 1966 Act. The wording is the same. Neither the right to work minerals nor an ancillary right shall be granted under this Act unless it is shown that it's not reasonably practicable to obtain the right in question by private arrangement for any one of a number of reasons, and only one of them, of course, as you're well aware, is an unreasonable refusal. There may be other circumstances in which you can't find someone who's got the power to grant you the right, and that 4(1)(a), for example, that the persons with power to grant the right are numerous or have conflicting interests, that might well have applied in the case of Remarkham. And then in Section 6, the opposite page, you can see that there's a reference to the Commission, which was replaced by the Court in 1949, where a matter is referred to the Commission. This is by the Minister. The Commission, if satisfied that the requirements of this part of the Act are complied with in the case of the applicant, and it's expedient in the national interest. And so that's an important requirement in each of these cases, expediency in the national interest, and there one can see the interest, the national interest, purpose behind this legislation, expedient that the right should be granted. And then going on to Section 9(2), there a distinction is made. It's not just the word compensation or consideration, or not just the word compensation, but it's compensation or consideration. Where a right to work minerals or an ancillary right is granted, or any restriction on the working of minerals is imposed upon this part of this Act, the Commission may determine the amount and nature of compensation or consideration to be paid or given if one's being entirely scrupulous, and one is expecting a symmetry between right to work minerals and ancillary right. One would expect compensation or consideration to be the other way around. But there it is. To be paid or given, and the persons to whom it is to be paid or given neither at the time. The compensation or consideration in respect of any right shall be assessed by the Commission on the basis, and there I've got these words. Just in passing, and I'm going to take you in a moment to Remarkham. Remarkham was not in my submission a case that was concerned with Section 9(2) at all. But I hope to make that good in a moment. Section 10(1), the provisions of the railway and canal traffic, this is 1988, as amended by any subsequent enactment relating to the procedure, and I suppose one should emphasise procedure for the determination of questions under that Act. Shall apply to the determination of questions relating to applications under this Act as if they were herein reenacted and in terms made applicable to the provisions of this Act. And then if you turn on, you can see one reference to the Land Clauses Act, 10(1)(d) over page. The rules regulating the procedure of the Commission may apply to any of the provisions, of the Land Clauses Act relating to the payment of compensation, so far as it's not inconsistent with the provisions of this part of this Act. That's the best I can do so far as a reference to the Land Clauses Acts.
Why does it use the word payment of compensation as opposed to assessment of compensation?
Yes, I'm not suggesting that I'm not saying that this means assessment. It's there are provisions in the Land Clauses Act for payment of compensation when it's for example, difficult. There is such a provision already in this Act, but it's difficult to find, or it's impossible to find the person you should be paying.
Right.
That then is the 1923 Act, and of course that was the legislation that existed at the time of the 1934 Act, and perhaps I can now ask you to look at the 1934 Act, which you'll find in Volume 2, tab 14. Sorry for that. The legislation was passed, and my submission is pretty obvious from the face of it, in order to encourage the exploitation of petroleum in Great Britain at a time when there had been very little exploitation of it under the 1918 Act, which you've been taken to. You will see on page 325 that there were only 3 licenses in force under the Petroleum Production Act 1918 at the time of the passage of the 1934 Act.
As a matter of interest, how many licenses for onshore getting of petroleum are in existence today? Is there a very large...
You're asking me a question which I don't know, but maybe I can come back to that.
Yes, I mean, it would be interesting. I mean, there's been so much development offshore by very big companies, of course.
Yes.
But, going around the countryside, one doesn't see many of these onshore ones, the kind we're talking about.
Nodding donkey.
Nodding, you see some in Kent.
Yeah. Nodding donkey.
The
40s, I mean, we were
The
talking.
agreed statement of facts, this is not in fact a complete answer, is that there are currently around 40 onshore oil fields in Great Britain. That's paragraph 23, page 7 of the agreed statement of facts. That it's not the same thing as saying that there are only 40 licenses. Licenses are granted, as you can see, for exclusive areas of particular territories in the country.
So
I'm told from behind me that there may be as many as 200.
right, thank you.
We'll check to make sure that.
Do we have the standard licence terms somewhere in the
Yes, we do.
You can give me the reference to that later on, maybe.
Yes, I am.
I think they're right at the back of Appendix 2, aren't they?
Thank you.
They're in 2 places in one, in fact, but our licence is at the end of Appendix Part 2.
Thank you very much.
Maybe very quickly, whilst we're looking at it, then this is the form of licence that was in existence in the relevant date for the purpose of the hypothetical negotiation. If you're looking at page 683, I hope we're both, you'll see that this is the licence. And clauses 1 and clauses 4 to 39 of the model clauses is incorporated herein. Clause 3 shall be incorporated in, have effect as if herein set out. And then C, in fact, mirrors one of the model clauses in consideration of the payments and royalties hereinafter provided and the performance and observance by the licensee of all the terms. The Minister in exercise of the powers conferred upon him by the Act grants the licensee exclusive licence and liberty during the continuance of this licence, subject to provisions hereof, to search and bore for and get petroleum in the area of 247.5 square kilometres. And there you can see on page 688 the percentages. And this is, in effect, are the royalty payments that are made. And you can see that there's the royalty payments, if you're on page 688, are in effect 5% of revenue. increasing to 12.5%. And so I did make the observation, or the observation has been made, that in fact the 12.5% that Mr. Crawford payable to the landowner, according to him, would in fact exceed the royalties agreed with the Crown. The 5% level was never in fact exceeded in relation to this oil field. There was always 5% royalty to the owner of the oil, but according
So
to...
is it, I mean, are we talking about of the same thing? I mean, the 12.5 is in respect of what? Gross value?
Yes.
Yeah, but the 12.5% being looked for here is in respect to the net. And indeed after the 12.5 has been paid.
Yes, this again going off
I mean,
a slightly different point, but
It's not very central, but I mean, I'm really not sure that you're right in simply saying it doubles the liability, so to speak, doubles the cream.
The 12.5% put forward by Mr. Crawford is 12.5% of gross.
Which 12.5%?
Mr. Crawford's suggestion, the judge, Mr. Justice Peter Smith, decided that it should be 9% of gross.
Gross?
No, yes, gross. So there's no discount, if you like, for expenses. Gross revenue, yes, gross revenue. That's 9% of gross revenue. But that's coming from the expert's analysis or the report that it should be 12.5% of gross revenue. It's not 12.5% of profit. It's 12.5% of gross revenue.
So without, therefore, taking into account the 12.5% or whatever it is that they may already have paid for the licence?
Yes.
So I mean, I don't know that it matters, but certainly that is not the impression I had of what we were told earlier. Anyway.
So there'd be 12.5% on this view, which the judge reduced to 9%, because he thought there might be an interesting debate about BP and Ryder. There's 12.5% payable, it says, to Bocardo as a landowner.
And what are the units referred to here?
Units here are tonne.
Find in 9.7 on 694, isn't
Model
it?
clause 9.7.
I haven't yet found how you value the petroleum. Whether it's the value to the seller or the value to the buyer.
Well, they're winning.
I assumed it's... I'm not sure I can answer that. I should be able to answer it tomorrow, but I'm not sure I can answer that at the moment. But it must be... Well, it's certainly a percentage of volume. It's not a percentage, it's certainly a percentage of volume. And so I assume it would depend upon the actual selling price. But I'll be told if that's wrong. So there is, so far as the oil company is concerned, there will be the royalty, because that's in effect what is being said, the royalty payable to the landowner, if Bocardo is right, and then in addition there will be a royalty payable to the Crown, which, as it happens, will be less, although the Crown owns the oil, than the ransom value payable to the landowner.
I think going back to Lord Walker's question, I think I'm right in saying that there are recognised figures available in the market for example, North Sea oil. Just simply a barrel of North Sea oil has a recognised market value.
Yes.
Obviously, when it's taken on shore and refined and various things are done to it, it changes value. But there are figures for values according to particular places where the oil is got. And that reflects the quality of the oil, I think, in the area from which it's won.
Yes. There must be an answer to my Lord Walker's question, but I'm afraid
I mean, there's some provisions about value in paragraph 9.
Yes, there are. 9.3.
But,
You will see that in the standard model clauses, it's envisaged that by model clause 2, but this is actually repeated in the license itself, that it would be an exclusive license and liberty within a particular area. And you'll see that there are various obligations on the license holder, page 698, to, so to speak, work the area. Yes, I'm told that in practice the petroleum is valued for these purposes on the basis of the price for Brent crude.
Yes, that sort of thing, yes.
There are various obligations, and you can see at 699 there are development and production programs that the licensee must undertake, and so on. A provision which is mentioned in the printed case is model clause 37.2 on page 711. The licensee shall not enter into any agreement, I'm thinking here now in terms of the hypothetical agreement, which is at the foundation of the common law assessment of damages, providing for a person other than the licensee to become entitled to, or to any proceeds of sale of any petroleum, which at the time when the agreement is made has not been, but may be won and saved from the licensed area. In BP and Ryder, the landowner took the view that the agreement that it was that they were suggesting, namely that they should be paid a royalty by reference to the value or the selling value, the selling price of the petroleum, would conflict with Rule 37.2. The Court of Appeal did not take the same view in this case. But there it is. Those are the model clauses. If I go back to the Petroleum Production Act of 1934, it enacted quite clearly, without looking at Hansard in my submission, because it was thought to be in the national interest for the oil to be nationalised and for there to be a scheme of development of the oil fields by means of licences. Section 1, subsection 1, not only vested the property in the petroleum in the Crown, but also gave the Crown the exclusive right of searching and boring for and getting such petroleum. No one else in this country may therefore lawfully search and bore for and get petroleum. Searching for is usually done by way of seismic survey to begin with. Section 2 contains the provisions for the grant of licences. The Board of Trade shall have power to grant to such persons as they think fit licences to search and bore for and get petroleum. So that's the licensing regime, which led to the grant of the licence in this case. The Board of Trade is given a certain amount of leeway. Section 3, Part 1 of the Mines, as amended by any subsequent enactment, shall apply for the purpose of enabling a person holding a licence to acquire such ancillary rights. So we're not thinking here in terms of rights to work, but ancillary rights only, as may be required, obviously because the petroleum is vested in the Crown, as may be required for the exercise of the rights granted by the licence, shall have effect accordingly, subject to the following modifications. And so the Mines Working Facilities and Support Act 1923 takes effect, and so does the 1966 Act, subject to Section 3. So Section 3 imposes certain further requirements so far as assessment of compensation is concerned, over and above those contained in Section 9.2, Section 8.2. And then without 3.1b, without prejudice to the generality of subsection 1 of section 3 of the said Act, the ancillary rights therein mentioned shall include, in addition to the rights specified in subsection 2, a right to enter upon land and to sink boreholes therein for the purposes of searching for and getting petroleum. This is really in connection with an argument that I have so far as the tort of trespass is concerned, but in my submission there, the use of the phrase "a right to enter upon land and to sink boreholes therein" naturally reads as a right to enter upon the surface of the land. It's very difficult to see why that expression, "a right to enter upon land," should in fact mean a right to enter through, under, or in land, but it looks pretty clear in my submission that a right to enter upon land and to sink boreholes therein is actually referring to a right to enter upon the surface. And then that's the right to enter land and sink boreholes, and a right to use and occupy land for the erection of such buildings, the laying and maintenance of such pipes, and the construction of such other works as may be required for the purposes of searching and boring for and getting and carrying away, storing, treating, and converting petroleum. And then two, this is the...
Can I just catch you on the proviso? What's this talking about?
That's to do with rights to lay under highways.
Pipes under a highway.
Mm. But I don't believe that it has any bearing on any decision which your lordships have to make. Section 3, subsection 2 does, of course, because this, to use it with this morning's word, is a gloss on the usual provision for the payment of compensation under the 1966 Act, 1923 Act as it was, in relation to any application made under Part 1 of the 1923 Act, as applied by this section, the following provisions shall have effect. So these must apply whenever there is an application by a licence holder. The Commission shall, in deciding whether to grant any right applied for, or what terms and conditions, if any, should be imposed upon the grant of such a right, have regard, among other considerations, to the effect on the amenities of the locality of the proposed use and occupation of the land in respect of which the right is applied for. And so there is a public benefit interest which is identified, or detriment which has been identified, and which the Commission must consider in this particular context only. It's an added requirement in the case of petroleum. But B is important in my submission. In determining the amount of any compensation to be paid in respect of the grant of any right, an additional allowance of not less than 10%, shall be made on account of the acquisition of the right being compulsory. Now, it seems to me, as my submission, that this is a clear contemplation by Parliament that what we are talking about here is the acquisition of compulsory rights. Maybe that's not really an issue. This is quite clearly regarded as compulsory acquisition. That's what it says. And again, the word used is compensation. Now, this is legislation which is being drafted in the context of the 1923 Act, where the words used are consideration or compensation. And in my submission, these words are completely correct, because what one's doing here is not acquiring any asset. One's acquiring rights, and all that means is that the landowner is entitled to be compensated. You're not buying a right, you're compensating the landowner for the loss. Again, the 10% allowance is unusual if, indeed, the landowner is to be compensated, if that's the right word, is to be compensated for its ransom value, or the ransom value in the land. The suggestion, I think, was made yesterday, and my submission must be right, that this provision would in fact enable a person to argue, when it comes to the common law damages, for a higher payment of compensation because of this minimum 10% uplift than would otherwise be the case. Because not only is the, if one does include the ransom value, not only is one looking first of all at what the reasonable, what would be fair and reasonable between the willing grantor and the willing grantee, let's say that's £100,000, but also, it would be reasonable and right for the willing grantor to say in that context, well, actually, I want more than that because statute gives me an extra 10%, so I'll have £110,000. Which, in my submission, is odd. It may well be a conclusion that one could reach to, but it's an odd conclusion to come to, that as well as being paid a sum which would equal what is fair and reasonable between a willing grantor and a willing grantee, one is getting an extra 10%. Now, the historical...
I'm not sure there's any problem with this. Look, I mean, if you've got a willing grantor and a willing grantee, what's fair and reasonable may be one thing, even if you are having regard to key value. You know, you're having regard to a reasonable key value. But that's on the postulate that it's a willing seller who is actually, therefore, prepared to give it. But as it's compulsory, and he may not want to give it at all. And certainly, if it hadn't been compulsory, he might have been able to drive a better bargain and get more than a reasonable key value. He might have got a thoroughly unreasonable key value. So the statute says, well, because we're making him, deeming him willing, and therefore fixing perhaps a lower charge for what for the key value, whatever it may be, we'll give him an uplift of 10%, upwards of 10%. I mean, is that an incoherent explanation?
Well, plainly
Certainly
it's not
wasn't
an
very
incoherent
articulately put,
explanation.
but that's another point.
But it's a provision which one doesn't find in the context of the 1923 Act as a whole. It doesn't apply in relation to any mineral other than petroleum. And so there is no provision for an uplift if one's, for example, buying brick earth or coal, or seeking to acquire the right to work brick earth or coal. There's no requirement that one pays 10% above the...
I mean, previously this idea of 10% extra or X% extra came out in the cases, did it? Was there there was no previous statutory provision about it?
But then there was the abolition, as you say, in respect only of public authorities.
Yes.
No allowance should be made on account of the acquisition being compulsory. Yes. That was to get rid of the old common law uplift.
Yes, yes it was. I can draw, therefore, the contrast between this provision, which applies in relation to ancillary rights in respect to petroleum, and the absence of a corresponding provision in the 1923 Act, which applies to all minerals, but also includes the right to work minerals.
If you have a mine, a coal mine, for example, which has to, it goes down vertically, let's say, and then has to project underneath somebody else's land, in the comparable situation, you wouldn't get the 10% uplift because it's coal rather than petroleum.
Yes.
That'd be right.
Yes.
But whatever the reason, does it help on the key value point?
Only in this way. The 10% uplift was a judge-made thing, and it was brought into play at the same time as what might also describe as the judge-made approach to valuation, and that was value to owner, not value to acquirer.
I thought you were taking something from the language itself as well. I mean, forget about the 10%, it could be 3 or whatever. But the fact that it says, on account of it being compulsory, you say, has a flavour of it, and the word compensation too, of the traditional compulsory acquisition formulae.
Yes. Yes.
So, I mean, that perhaps is your more powerful point than the fact that it's there.
It is
It's just the wording.
You then going on.
You say it points to the fact that the principles in the cases we were looking at, the Point-Gord principle and so on, applies here.
Yes. And of course, that is why my suggestion is that in this case it's important to construe the 1923 Act, the 1966 Act in the context of this legislation. This legislation sets up a scheme, and so the licensing scheme. And so it is perhaps inevitable that in the context of the scheme, if an application is going to be made by the license holder who's part of the scheme, that the point gourd principle of valuation is going to apply, and this is to some extent a recognition of that by Parliament.
As I said, I mean, some acts do incorporate the 1961 legislation, is this right? But ours doesn't.
Yes.
I mean, is that right?
Yes.
And you'll tell us at some point why that is.
I will attempt to do so tomorrow. It will be what I hope will be an educated guess on my part, because I don't know the precise reason. But I can think of some reasons. I just say this, that the legislation with which we're concerned elsewhere, the Land Clauses Act, the Acquisition of Land Act, they're concerned simply with the assessment of value or compensation, whereas so far as the 1923 Act was concerned, and in those cases, the acquiring authority would determine for itself what it wanted to acquire. The question then was what it would have to pay. So it would say, I want to acquire this property, and then the dispute would be as to what it would pay. In the case of this legislation, by which I mean the 1923 Act, it is left to what was considered to be an experienced body, the Commission, to determine other questions, such as whether or not it was expedient in the interests of the nation that the right should be acquired, and whether or not the right was expedient and so on, so that it fell within Section 3. And it may well have been decided that the same tribunal should determine also the amount of compensation.
Well, shall we leave it there and resume tomorrow morning at 10:30?
Yes.